Microphone VO1. Fire right out the gate, the judge drops a truth bomb. Imagine living every day asking yourself, is this a 20-year mistake? That's not a rhetorical question, that's survival.
All right, court is calling 2023 CR 6906, State of Texas versus Tyrie Joseph Ranford. Could our parties announce for the record for the state? Defense?
Monica Dinner for Mr. Ranford.
And are you Tyrie Ranford?
I am.
All right, you entered a plea on September 28th of no contest, and also a plea of true to the enhancement. And we're now here for sentencing. According to the plea bargaining agreement, punishment is to be assessed at 6 years in the prison, and the state is silent on your application. Have both parties had a chance to review the PSI report?
We have, Judge.
Any objections?
We don't have any objection.
All right, anything you wish to say on behalf of your client?
So I explained to Mr. Ranford what the court's policy is, and that many people ask you, why would you ever want to be on probation in the 187? Because when you mess up, you're going to prison. And that you make the probation conditions very, very difficult. I've explained all that to him, and I told him that you don't play around, that he will be drug tested, he will be checked throughout this thing if you give him the privilege of having probation. He said he understood that, and he wanted it to still apply. He also wrote a letter to you.
Up if it meant avoiding prison for 2 decades. Let us know in the comments. And yes, that includes sketchy group chats. Microphone VO2. This is the tightrope walk of Texas probation. Defense is practically begging for leniency, but this court, not the hand-holding type. You mess up, you go to.
He would like for you to consider the read. He thinks he would be a good candidate for probation because he's already getting too old to be messing around anymore, and he doesn't want to end his life having chronic back pain and trying to treat it himself. I don't know if you wanted him to read it to you or if you want me to tender it to the court.
If there's no objection.
No objection.
All right, if I could see the letter. All right, anything else you wish to say, Mr. Ranford?
No, ma'am.
All right, so sometimes I can give people choices, sometimes I cannot give them choices. It's obvious to the court that you have a drug issue, right? So if you want help for your drug issue, the court will give you help for your drug issue. Or if you would like, what I can do is I will sentence you to 3 years in the prison. Which would you prefer? Okay. There's an application for deferred adjudication. So with your application for deferred adjudication, if you are unsuccessful, then the full range of punishment will be open to the court, which is up to 20 years in the prison. You understand? All right, I'm going to sentence you to 8 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be the UA hotline. This is to run concurrent with County Court Cause number 698064, taking consideration 707108, night bag numbers 709145722 grand jury number 804578, proof of employment within 30 days of release, no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors.
To prison. That's not just a warning, that's a judicial tagline. Microphone VO3. Books. Let's pause here. Deferred adjudication sounds fancy, but here's the breakdown. It's a second chance, with a loaded trapdoor. If he messes up, it's open season for the full 20-year sentence. No takebacks. Would you roll the dice on that?
200 hours of community service restitution. Do you have any children?
No.
Will you be living with someone if you're released?
Yes, sir.
And who would you be living with? Okay, just 1 second. Let me see what the TAP evaluation tells us. All right. There's going to be a transfer to SATA. So you're going to stay in custody until you transfer it to SATA. And we can also do a referral to felony drug court. Felony drug court has a wait list, so they're probably not going to be able to accept you. So you'll be going to SATA. And upon release, I'm going to want 90 sober meetings in 90 days. Field visits, 1 time per month for 4 months. And then within probation's discretion thereafter. Probation, is there anything else he needs? All right, is there anything else you need from the court to be successful?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, sir.
Because this is a plea bargain agreement, because I call it your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, good luck to you. We can go off the record. You're going to have to make better decisions from here on out. Everything that you do, you need to ask yourself, could it result in you going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand? All right, and in this court, to be successful, your counsel probably told you communication is key. If you have an issue, let probation know. If you feel like they're not addressing it, you can always come to court, okay? All right, good luck to you. All right.
Microphone VO4. Bullseye, and we're back where we started. Make better decisions. Notice how the judge bookends the hearing with the same advice. That's not repetition, that's a mantra. And in this courtroom, it might be the difference between probation and prison jumpsuits. VO5. Sparkle's redemption.
Court is calling 2019 CR 10494W, State of Texas versus Angel Montoya. Can I have parties announced for the record for the state? Defense? Are you Angel Montoya? I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Angel Montoya who was placed on deferred adjudication in 2019 CR 10494W for the offense of possession of marijuana 4 ounces to 5 pounds on September 24th, 2019 for a period of 2 years? State?
On or about the 27th day of January 2021, in Bexar County, Texas, the defendant, Angel Montoya, did then and there fail to complete 50 hours of community service restitution in violation of condition number 14.
How do you plead to that? True or not true? Did you understand? I'm sorry. Are you waiving the other allegations?
Your Honor, the state waives and abandons the other allegations.
Any objections? Did you understand by pleading true to violation of condition 14, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition 14? Court will find violation of condition number 14 true. Is there a proposed agreement?
Yes, Judge. I've spoken with probation, spoken with counsel for the state, and we agree as well with the recommendation that her probation be terminated unsatisfactorily.
All right, what has she done?
Judge, what she has done is that while she was on probation, she had another incident out of Kendall County.
An arc incoming. Angel Montoya's story is a plot twist straight out of a docuseries, prison time served, clean drug tests, a fresh outlook. But here's a twist. She's getting terminated, unsatisfactorily. Why? Because past violations don't just disappear. Should her turnaround matter more? Sound off below.
Shortly after that, she spent 18 months in prison in 20 states, including Texas. recently released in July. Since that time, having spent that time in prison, she's changed her whole way of thinking and doing. When she was released, she was put on UAs for every week, no problems. Now she's on random, no problems. I asked her if I offered her up today for you to prove to yourself that she was clean and sober. She's perfectly willing right now to step up and do a drug test.
All right.
She's just done with that life.
All right. Based upon the probation's recommendation and agreement, the court will find violation of condition number 14 true. The court will terminate her unsatisfactory. What is happening with 2022 CR 0054?
Judge, 2 days ago, Mr. Dunn and I spoke. I brought to him new evidence, not new evidence that we found, but we were waiting for the evidence because the person that we were getting evidence from was incarcerated himself. But I've had 2 conversations with him since then, and the information he has given me is material and substantial to this allegation, and I am giving that information to Mr. Dunn to interview my witness.
All right. So with regard to the cause number 2022 CR 0054, if we can get a reset on that for November 30th.